wanted to be here.
Yeah.
So shout out to Stockton. Okay, now how did you trademark the word? Because I've trademarked words. I never thought of trademarking the word I've heard my whole life. Mama used to call me the white woman. She did though.
Yeah.
How did you trademark the word and why did you do that?
Tupac. I got the word made too.
Hold on. Did he just say that his mom, who was white, used to call him the N-word? That's crazy. If you guys don't know, I am Dave, almost 10-year intellectual property attorney. I was sent this video, which I'm going to break down. Does Charleston White have a trademark on the word? You know the word. I know the word. I'm not going to say the word, but does he have a trademark? As in Jason Lee, the founder of Hollywood Unlocked, he's asking him, and it seems like Jason Lee, has trademarked a ton of words, which again, it's just showing you the value of this IP, specifically in this case, a trademark. But he's asking Charleston White, does he have a trademark, or what made him trademark the word? Again, if you can see here, he even has a chain on. Let me go to it again. He even have a chain on in nation. That's his chain, in nation. Again, I'm not going to say the word, but I do want to bring some of the facts or provide some of the paperwork here. So let's go to the USPTO site first and foremost. We're gonna see what is the word that we're all talking about here. Hey man, probably should have I did this beforehand. This is the word that we're talking about here. Put it like that. This is the word that we're talking about. And you actually, Charleston White, he doesn't kind of talk about it a lot more, kind of promote it or have t-shirts and apparel with it. He used to have the word Texas in nation. Now, this was the trademark application that Charleston White did file with the United States Patent and Trademark Office to trademark that logo as well as that word. Again, let me bring it back on the screen for those of you who didn't see it. He filed a trademark for the word, or the phrase, I should say, Texas in nation, with in the background the state outline of Texas. That's what he filed for trademark protection for. Now, the interesting thing for me, as we're going to continue to play this video, is that Charleston White didn't maybe correct Jason Lee as he talked about, hey, what made you trademark the term, or you have a trademark on a term. He did file for a trademark application, but he doesn't have a trademark on the term. What do you mean he doesn't have a trademark on the term? Let's break it down. I'm going to show you the paperwork here. I'm going to show you the paperwork. Here it goes. So this is the first piece of paperwork that I want to let you guys know. When you file a trademark, and I'll bring it back on myself for a second. When you file a trademark application, when that trademark application gets examined by someone at the USPTO, you typically have what is called an office action that's being issued. So the examiner, in this case, the trademark examiner, is going to say either, hey, you can't get a trademark on this term because these terms or this word or this logo exists, and therefore you either have to argue back and forth with the examiner, or you have to essentially change the term up. Make an amendment is what we call it, to change the actual mark or the logo that you were trying to get trademarked, to maybe include some things, maybe take out some things, to hopefully put it in a condition for allowance. So that's the first way. The second way is you don't get any office action, or it's a first action allowance. Pretty much the United States Patent and Trademark Office is saying to you, hey, your application is good. The mark is essentially allowable. You have to do a couple, jump through a few other hoops, but based on our examination, there's nothing out there that will prevent you from getting a trademark. Those are typically the two ways that the USPTO responds to your trademark application once an examiner picks it up. So I'm going to show you guys the office action that was issued, and we're going to try to blow this up here. Hopefully you guys can see it. It says, again, this is a non-final office action issued June 1st of 2022. So and again, you see the applicant up here, Charleston Jamone. That's an interesting middle name, Jamone White Sr. So what were the search results? This is search results right here. If you see the highlight, hopefully you guys can see this. This says search results. So what were the search results of the examination? So it looks like the trademark examiner saying the trademark examining attorney searched the USPTO database of registered and pending marks and found no conflicting marks that would bar registration. Now, this is actually a good thing for Charleston White. And you guys may be thinking, hold on, how can you get a trademark and protect that term? Back in 2019, you used to cannot protect disparaging trademarks or logos. The USPTO had a rule that you couldn't protect those. But 2019 case went to Supreme Court, and the Supreme Court, they said that kind of violates your First Amendment right. So it gave you the ability to potentially trademark these crazy disparaging terms that you previously would not have been able to. So I think we can all agree that when you say that word, it's polarizing depending on who you're asking. And typically you couldn't protect that type of a word because it would disparage and mark, but now you can protect those type of words. One of the things that I do want to clear up that Jason Lee has said in an interview in terms of protecting that word. Now, when you protect, anytime you file a trademark application, you have to give what class that you're going to protect it in. It's no thing where you're submitting a trademark application, you can protect that word for everything under the sun. So in other words, if I was to, actually, he had a chain called In Nation. He actually protected the word for clothing and apparel. He didn't protect it for jewelry. So if someone was to kind of make a similar chain, he wouldn't have been able to go after them for trademark infringement because he doesn't have a trademark, or he wouldn't have had the trademark of In Nation for jewelry. He only filed a trademark application to protect it for clothing. So if he had a shirt, if he had on a hat, some sweatpants, maybe, whatever the case may be that was dealing with athletic or apparel, he would have been able to go after someone if they was to use that word for apparel. But if it was jewelry, if it's a plumbing company, another company that's outside of apparel, he wouldn't have been able to go after them for trademark infringement. So I did want to clear that up, because the way it was kind of phrased was like, hey, he has this this N word that is and it can be a little bit uncomfortable talking about it, but I think this is a very important, and it can be an educational thing in terms of me trying to provide some value on breaking down this clip. But again, he wouldn't have had the term in for everything under the sun. It would have been strictly for apparel. But the interesting thing is, as we go back up to the office action, this is what the examiner says. Disclaim: the applicant must disclaim the descriptive word Texas apart from the mark as shown because it was merely geographically descriptive of the source of applicant's good. Additionally, applicant must also disclaim the design of the outline map of Texas because it's primarily geographical, descriptive of the origin of applicant's goods. So pretty much what the examiner is saying there is, hey, you have this Texas In Nation, you have an outline of the Texas map. You have to disclaim, or saying that you're not claiming the map of Texas as well as the word Texas. So let's go back to the trademark application that I was saying that he actually filed. You can see here that he filed a trademark application on this logo, which again includes the word Texas In Nation and an outline of Texas. So the examiner is saying, hey, we didn't find anything that's going to bar you from getting a trademark application on it. But you have to disclaim or say that you're not claiming the map of Texas as well as the word Texas. So in other words, what you're effectively claiming is the word In Nation. So that's what the examiner is saying. So, hey, this is, and I guess Charleston White didn't want to do that because what happened? What happened? And this is what I think the video that Jason Lee, put out of Hollywood Unlocked kind of told part of the story. Here we go. Again, I'm doing some homework for you guys. So this is, again, trademark application abandoned for failure to timely respond to an office action. You see the owner here, Charleston White, Charleston Jamon White, and this was issued December 16th of 2022. So as you can see here, it's talking about the application above is abandoned because we did not receive a response to the previous office action within 6 months. So you have to, when you get an office action from the USPTO, you have to trademark you have to respond to the office action within 6 months. If you don't respond, that application goes abandoned. I actually had a buddy who, his situation had the same thing. He went to an attorney, the examiner at the USPTO said, okay, you can get a trademark on this, but you have to disclaim these few things. And he just didn't respond. On his case, the attorney didn't tell him about it, and that was a whole nother issue. But all Charleston White had to do was disclaim the outline of Texas and the word Texas, and he would have gotten an actual registered trademark on the term in nation. However, he didn't do that. That trademark application went abandoned, which means that he has no claim, no rights, no claim to fame of the word in nation. Why is this important, David? Because as we go back to the video here, Charleston White doesn't, and we're going to go back here. Oh, shucks. Because Charleston White doesn't clear that up.
On my show.
So he said Tupac made him trademark the word, but he's not telling the full story. Look it, we did file a trademark application on that, but they was asking us to do X, Y, and Z, and we didn't want to do that, so we let the application go abandoned, and we know we don't have a trademark on that. He didn't say that. Hey, heck, man, look it. I had a story where when I graduated law school many years ago, I was fortunate enough to be able to drive to the graduation in a Bentley, and people, they knew that. Okay, man, he drove to law school in a Bentley. I wasn't letting people, when people asked me that, I didn't say, yeah, man, I either correct them if they think that was hey, that wasn't my Bentley, but I, was able to use a Bentley and drive to graduation. But a lot of people, a lot of times when they talk about it, they knew it wasn't my Bentley. But again, if it was my Bentley, I wouldn't have tried to let people make believe that that's my Bentley. I would have cleared that up. So in this case, he doesn't say, hey, man, you know what? We did file for a trademark application. But again, because of X, Y, and Z, they was asking us to do some things that we didn't want to do. We didn't think that the mark still had the same amount of value. I pulled back. He didn't say, which is interesting why he pulled back, because he still has in a nation on the chain, which is interesting that he just didn't disclaim those elements of the original application and go forward. So again, at this point, based on the paperwork, at this point in time, he doesn't have a registered trademark on that term. However, he doesn't clarify that with Jason Lee. Let's go to another portion of the video, and we're going to get you guys up out of here. Let's go to another portion of the video where they are kind of talking about it a little bit more in detail. And again, he still doesn't kind of clear up that fact.
Out to go break back in to keep breaking out, man. So she kept doing it. That's what make her who she is.
So you owning the word and now nation is on your chain.
Yeah, never
What
ignorant,
is
never ignorant getting goals accomplished. All the pole that everybody does. The pole the me is like the dog.
So that's interesting. So he actually, that word is an acronym for never ignorant. Well, what did he say? Hold on, let's go back to it, because I didn't know that. I didn't know that this was an actual acronym for another, maybe organization or something that he was running.
Never ignorant getting goals accomplished. All the pole.
Never ignorant getting goals accomplished. That's what his N word stands for. Again, everybody loves to do the acronyms, and the acronyms do work for you being able to remember things, but it's never ignorant getting goals accomplished. That's what he has. That's why he uses the word in nation. Again, they talked about it having him on the chain, which is interesting because he filed for a trademark for apparel. So that wouldn't have protected the chain of the word on there. And if somebody was to use or kind of create and sell the chain with it on there, he wouldn't have been able to go for him for trademark infringement, because he doesn't own, or he wouldn't have protected the word in that class, in a jewelry class. He would only have protected it in the class dealing with apparel, which again is interesting. But again, I just wanted to kind of correct that, because a lot of people watching that portion of the video, they would have thought, oh man, I didn't realize that Charleston White had a trademark on the term, which again, he filed for a trademark application, but it was never allowed. And as a 10-year intellectual property attorney breaking this stuff down, I just wanted to correct that fact. You have to be sure to respond to these office actions. I'm not sure if this was intentional on his part or unintentional. He may think, hopefully he doesn't think that he still has his trademark application going and the attorney didn't respond and didn't let him know, because clearly he didn't clear that up with Jason Lee, and they all think that he owns the trademark to the word, which again, I showed you the paperwork. That's just not the case. He filed the trademark application, but it went abandoned because he didn't respond to the non-final office action. He could have had that term registered, because the trademark application said they didn't find anything that would prevent him for trademarking that term, but he had to disclaim a few elements, the word Texas and the state, the map of Texas, but he again didn't respond to the office action. It was the case was abandoned, and therefore he doesn't own the word in nation based on what we just looked at. So hopefully you guys got something out of that video. Sorry for bleeping out the N words, but again, I'm trying to be monetized on this thing. So hopefully you guys got something out of that. Until next time, Peace.